A big topic of conversation during 2016 and into 2017 are things like the gig economy. We're very slow to respond to changes in technology, changes in ideas, and the gig economy is one of those. So we have the Uber decision in the UK, and although there's not one in Ireland, I do think it's going to be highly relevant to the way in which we deal with the gig economy moving forward. So for 2017, we really need to watch that space, and we really need to see how we deal with that particular issue. Also, the government has responded to a lot of pressure with respect to 0 hours contracts and so on. And they've issued a bill to deal with atypical workers who are on those insecure low-hour contracts. So again, that's an area that's going to be of interest during 2017. During 2016, we saw a lot of industrial disputes, particularly in the public sector. We had the Gardaí, we had the Dublin bus drivers, we had the secondary school teachers. So what does that mean? We have the Lansdowne Road Agreement, which is due to run until 2018. I think it's highly unlikely it will go the distance, and the government will come under increasing pressure to deal with the public sector, and we have to see where that goes. And I think that will be a feature of 2017. Insofar as the private sector is concerned, we've seen the advent of the Industrial Relations Amendment Act in 2015, but the first real decision under that Act was the Fresh Waste case in 2016. What that means for private sector employers is that the Labour Court can intervene in a dispute so long as certain preconditions are met, whereby they can enforce a binding recommendation on an employer such that it will affect their terms and conditions of employment. I absolutely think that's going to be coming to the fore during 2017, and employers will need to be prepared for that. In 2014, we saw the advent of the Protected Disclosures Act. It's really taken some time to show its teeth, but during 2016 there were two significant cases where employees were successful in obtaining injunctions from the Circuit Court. This effectively meant that they were put back at work or indeed paid pending the outcome of the unfair dismissal hearing. It's a low evidential bar that the employee has to meet in order to successfully apply for that injunction. In addition, we had a penalisation case where an employee was awarded money on foot of being penalised. So coming forward to 2017, I think we'll see a lot more of that, coupled with the fact that an employee can get an award of 5 years' pay in circumstances where they are terminated on foot of a protected disclosure. It is something that employers will need to watch out for.